This is Sue Ricketts from the Nystagmus Network, and I'm joined today by Mike Cain, who's an associate solicitor specialising in employment law and workplace discrimination with Leigh. I'm very pleased to have Mike here. We're going to be discussing visual impairment in relation to employment law. Hello, Mike. Nice to see you.
Yeah, hello. Nice to see you.
So the first thing I'd like to ask you is, what are the rights of a visually impaired employee and what are the responsibilities of the employer?
Well, I think the first thing to say, Sue, is that the law in particular, the law at work, defines disability, it's per se, disability functionally. So that any physical or mental impairment, which is substantially adverse in a long-term way, that impedes getting on with everyday tasks, including those required at work, is classed as a disability. Now, the law deems severe sight impairment or being partially sighted, where that is certified by a consultant ophthalmologist. So I suppose that would correlate with being registered as a deemed disability, which means that, as I understand it, and my understanding is limited, is that most forms of nystagmus, where they are so certified, would automatically qualify as disability in the employment law context. Now, where that is not the case, it's still possible that nystagmus, as a suffered condition, could satisfy the disability definition, where the nystagmus is long-term, which means that it has lasted for or will last for more than a year. It's substantially adverse, and that is always, of course, a question of fact and degree. And if it's impeded in carrying out the everyday tasks, including work tasks that are required in a given job. Now, it's crucial to understand that the law, when considering disability status for the purposes of law at work, and perhaps artificially, this often strikes people as artificial, is interested in the way a condition affects somebody before or when it is not treated. So if you have glasses or medication or such like, it's the effect of the condition that you have before that treatment that's looked at to decide in a workplace setting whether you have a disability. Now, this means that more people will fall into the category than would be the case when it comes to legal protection and employer obligations. Now, employers have a wide range of obligations when it comes to protecting and addressing the needs of disabled staff, and I'll go through these. There's a duty not to treat a disabled member of staff less favourably than a non-disabled employee in the same workforce and in the same circumstances. The comparison can be with an actual employee or a hypothetical one. So there doesn't need to be another person who isn't disabled. You can draw a comparison with a hypothetical individual who didn't suffer the disability. For disabled people in particular, and this would include those partially sighted nystagmus, there's a duty not to treat a disabled employee unfavourably. And the difference between less favourable treatment with a comparison and unfavourable treatment, there's no need for a comparison. And the key difference is that lack of comparison. So unfavourable treatment because of something arising in consequence of a person's disability that can't be justified where the employer knows of the disability, that's a duty. There's a duty to make, and many people will have heard of this, reasonable adjustments that alleviate the disadvantage arising from a particular thing which the employer does. We call this a provision, a criterion, or a practice, compared with how that same provision, criterion, or practice doesn't have a negative effect or create a disadvantage in a non-disabled employee. The range of adjustments we can come to in a moment, but they're as wide as the capacities of the employer to provide them. And the law would expect an employer to provide adjustments to assist and alleviate disadvantage where it was possible to do it. There's obviously a duty not to harass a disabled employee by creating an intimidating, hostile, degrading, humiliating, or offensive environment, or violating the dignity of the disabled employee. And employers are liable when their employees do this, which is another key takeaway point, I think. Now, There's a duty not to impose on a particular on an employee a particular way of working, which might be being applied to everybody, but has a disparity of impact and a negative effect on a group of people with a particular disability, which it wouldn't have across the rest of the workforce. And that's what we call indirect discrimination. There's also a further duty, which I think is less well understood in relation to harassment, which is not to victimize a disabled employee by reason, not of the disability, but by reason of the fact that that person has tried to do something or said something to assist themselves in relation to their rights, in relation to equality and in relation to disability. So this is quite a different kind of protection, and it's a protection from reactive hostility or retaliation from an employee who tries to advance their rights in this area, and we call that victimization. Now, where these obligations are not followed, an employee can bring a claim in the Employment Tribunal under the Equality Act. Where a claim is successful, it can result in compensation, including compensation for injury to feelings separate to injury to health. And recommendations can be made that are designed by the tribunal that are designed to stop the ongoing disadvantage where that occurs. Employees must first raise a problem with their employer to see if the problem can be solved. That would be expected. And beyond that, before going to the Employment Tribunal, there'd be an opportunity to go to an organisation called ACAS, the Advisory, Conciliation and Arbitration Service, who can sometimes head off a problem before a claim starts. And in fact, that's a prerequisite to going to the Employment Tribunal. And there are strict time limits within which a person has to go to, very short and very strict time limits within which a person has to raise a complainable issue. And that time limit in the main is 3 months minus a day before a person raises it. So it's really, I think the key takeaway here is that people have to be prompt in advancing their concerns in relation to a disability issue which isn't being handled properly in accordance with the employer's obligations.
Okay, that's brilliant. Thank you very much. Very comprehensive. So if someone has nystagmus but they haven't told their employer and it begins to affect their work or their work changes, how should they approach their employer for support? What services are available to the employer and the employee?
Well, we mentioned ACAS a moment ago, which is an external organisation that can be very helpful. Most employers, especially employers over a certain size with a human resources facility, should have a policy which allows an employee to raise a condition. Alongside a grievance policy, there's often a much less intimidating occupational health policy or practice. So an employee should be able to raise that welfare issue with the employer in an appropriate and meaningful and compassionate way. When things go wrong with an employer in this area, an employer being able to show that they didn't know about the disability is a defence that that employer can have if an employer first hears of this matter in an external complaint to the tribunal. So it's quite important to presume, especially given that most employment relationships are meant to embody a term of mutual trust and good faith on both sides, trust and confidence, that it should be the case that an employer can raise an issue and expect to have that issue dealt with compassionately and meaningfully. It's very difficult to give specific advice, and I emphasise that nothing I say in this discussion we're having today is intended as individual advice to a given situation, and situations can differ so much. But it is that what I would want to emphasise is that people should seek out first, in a first instance, their internal opportunities to raise these issues with the people in the organisation. In the much smaller workplaces, I appreciate entirely that this can be difficult. Somebody working with 2 or 3 other staff in a small family-owned business, things can be more difficult. But even then, these duties are embedded, and there are minima of obligations that an employer should have regard to in considering the matter when it's brought to their attention.
Okay, thank you. Clear enough. So if someone has recently acquired nystagmus and needs time off work and support to return, what reasonable adjustments can they expect from their employer?
Well, I mean, we mentioned reasonable adjustments before as one of the sets of duties that an employer has. Now, both the good and the bad thing, in my view, about the reasonable adjustments idea and the way that it operates within employment law is that it is flexible. And what I mean by that is that the flexibility is such, the flexibility doctrine is such, that what is reasonable to expect a large employer to do when faced with an employee's need in relation to a condition like nystagmus might not be something which a much smaller employer could be expected to offer or provide. And that makes life difficult to give precise answers to this matter. But there is a minimum level of support, however, that all employers would be expected to provide for. And having time off in relation to sickness, as we all know, and treatment is one of those areas of provision that I personally think it would be extremely difficult for any employer to refuse, at least for a short period. But the length of what is reasonable in terms of time off is a flexible point and would be resource governed in the context of that particular set of circumstances for the employee.
Right, okay, thank you. Yes, that can be very relevant for people with acquired nystagmus. So at what point in the job application process, if at all, should someone disclose that they have nystagmus? Are there any advantages or disadvantages to disclosing?
We have to be very careful about what we tell people to do because we don't know what their individual employment circumstances will be, and employment workspaces and staff and management can differ enormously. But again, I do refer and I would emphasize these minimum protections and standards. And what I can say is that the rights and protections that apply to a disabled employee who is in an ongoing employment situation, who discloses their condition, apply in the main to a disabled candidate who discloses their condition in the context of a job application. And it's important to note that the law allows for a claim, and this is quite an important point, not just to do with applying for a job. This would apply to somebody in an ongoing job as well as an applicant for a job. A claim based on the perception that an individual is disabled, as well as its existence in reality as a disablement, where it is declared. Now, I think that that could potentially be quite relevant for somebody with nystagmus, because my understanding, which is limited, is that as a condition, it can often be very visible that a person suffers from nystagmus.
Absolutely, yeah.
And even where that person, so you could find that we were talking before about victimization and how victimization isn't a claim based around the substance of the person's condition, but the way that they might fight for their rights or suggest that they want some assistance and then they're mistreated as a result of that. Well, if someone suffers from nystagmus and then people perceive of that person as having disabilities and exclude them from opportunities or mistreat them as an ongoing employee, or exclude them from consideration in a job because of a perception of that condition as exhibited, then that is certainly something which the Equality Act, the protective veil of the Equality Act, falls over. And so applicants should feel as encouraged that they have this protection as well as ongoing employees do. Now, as a final guide or pointer for people, I thought it was worthwhile to draw people's attention to the fact that the Equality and Human Rights Commission, which is known as the EHRC, produces a code of practice on employment, which sets out in great detail some very, very useful guidance for employers, especially in the area of reasonable adjustments. And in particular in Chapter 6 of the guidance. And it might be that the case that the network wants to produce a link to the Equality and Human Rights Commission guidance, which is updated from time to time, as a place to go to get more information in relation to how they think their employer might be able to assist them. And it's a good guide, and it assists people if they're writing a letter or thinking about how to approach their employer in the first instance in relation to their condition.
We definitely will do that, thank you.
And so I would really suggest that as a definite forward point for the future.
Yeah, absolutely. We will make sure that people have that link available when they're looking at this presentation. Mike, that was really a comprehensive discussion of nystagmus in relation to employment law, and I'm sure lots of our community will find it really, really useful. Thank you so much for going through that with us today, and thank you so much for your time and your expertise.
It was an absolute pleasure. Thank you very much.
Thank you.